Mr. President, I am Michael Okweyemi Bamidele. I represent Ekiti Central Senatorial District. Mr. President, I move that the Senate do receive and consider the report of the Committee on Judiciary, Human Rights and Legal Matters on the Court of Appeal Act 2013 Amendment Bill 2022, SB 670. Mr. President, I so move.
Benue Northwest. I rise to second the motion ably moved by the chairman of Judiciary, Human Rights and Legal Matters. I so second.
Thank you. Distinguished colleagues, that the Senate do receive and consider the report of the Committee on Judiciary, Human Rights and Legal Matters on the Court of Appeal Act 2013 Amendment Bill 2022. Say aye. Those against say nay. The ayes have it.
This is the report of our committee on a bill for an act to amend the Court of Appeal Act 2013 by increasing the number of justices of the Court of Appeal from 90 to 110. Mr. President, the Court of Appeal Act 2013 Amendment Bill 2021 SB 670 was sponsored by distinguished Senator Chukwuka G. Utazi, representing Enugu North Senatorial District. The bill was read for the first time on Wednesday, 10th February 2021. On Wednesday, 24th, 2021, the Senate at its plenary sitting deliberated on the general principles of the bill. After extensive deliberations, the bill was read for the second time and referred to the Senate Committee on Judiciary, Human Rights and Legal Matters for further legislative action and to report back with its recommendations. Mr. President, distinguished colleagues, I am on page 2, briefly stating the objective of the bill. Basically, the bill seeks to increase the number of justices of the Court of Appeal from the current 90 to 110 justices. The legislative intent of this amendment is to ensure that the court has the requisite manpower to allow for creation of more divisions of the court and to bring the court closer to litigants in line with the current realities aimed at expediting dispensation of justice. This is necessary in order to eliminate delay in the justice delivery system as it relates to the adjudicatory powers of the court in tandem with its appellate jurisdiction. This proposed amendment undoubtedly is targeted at reducing the workload of the court and enhance its effective performance. I proceed to page 6 to talk about the findings and observations of our committee. Our observations and findings flowing from the submissions and presentations made by stakeholders and the general public on this proposed legislation, and having analyzed same in our subsequent markup sessions on the bill, our committee hereby makes the following observations and findings. 1, that the stakeholders were unanimous in their support for the passage of the bill because of its systemic and strategic relevance to the justice sector reform aimed at bringing justice as well as access to justice closer to the people. 2, that the amendments sought by this bill, if eventually enacted as an act of the National Assembly, will ultimately reduce the docket of the Court of Appeal, as well as stimulate quick dispensation of justice. 3, that one of the salient provisions of the new improvement on this bill is the aspect that seeks to integrate virtual court proceedings, which has become an integral part of our court proceedings in recent time. This is also in line with the guidelines given to courts by the Chief Justice of Nigeria, and a welcome development, as justice will no longer be delayed due to unforeseen situations like the COVID-19 pandemic that stalled judicial activities during its ravaging period. Number 4, that the proposed new amendment also seeks to align the provisions of the Extant Act with the provisions of the Nigerian Correctional Services Act, which was enacted as an act of the National Assembly in 2019. And finally, that the bill, as amended, seeks to formalize the convention of having 5-member panel of justices to hear election appeals and issues on appeal that are novel, uncertain, and recondite. Our recommendation, Mr. President, distinguished colleagues, the Senate Committee on Judiciary, Human Rights and Legal Matters, to which this bill was referred, having favorably considered same, recommends as follows: that the Senate do consider and pass the Court of Appeal Act 2013 Amendment Bill 2022 as amended. I so move, Mr. President.
Mr. President, distinguished colleagues, I move that the Senate resolve into committee of the whole to consider the report. I so move.
Minority Leader.
Mr. President, distinguished colleagues, I rise to second the motion that the Senate resolve to the committee of the whole to consider this report. I so second.
Distinguished colleagues, those in favor of the motion say aye. Those against say nay. The ayes have it. Clause 7, Clause 8, Clause 9, Clause 10 stand part of the bill, say aye. Those against say nay. The ayes have it. Clause 11 is on page 6. Those who are at Clause 11, Clause 12, Clause 13, Clause 14, Clause 15, and Clause 16 stand part of the bill, say aye. Those against say nay. The ayes have it. Those who vote at the interpretation stands part of the bill, say aye. Those against say nay. The ayes have it. Those who vote at the short title on page 13 stands part of the bill, say aye. Those against say nay. The ayes have it. Those who vote at the explanatory memorandum on page 13 stands part of the bill, say aye. Those against say nay. The ayes have it. Those who vote at the long title on page 1 stands part of the bill, say aye. Those against say nay. The ayes have it. Leader of the Senate.
Mr. President, distinguished colleagues, I move that we revert to plenary and report reports.
Minority Leader.
Mr. Chair, I second the motion that we revert to plenary to report progress. I so second.
Distinguished colleagues, those in favor of the motion that the Senate reverts to plenary for the chair to report progress, say aye. Those against say nay. The ayes have it. The Senate, in the Committee of the Whole, considered the report of the Committee on Judiciary, Human Rights and Legal Matters on the Court of Appeal Act 2013 Amendment Bill 2022 and approved as follows. Long title as recommended, Clause 1 to 16 as recommended, interpretation as recommended, short title as recommended, explanatory memorandum as recommended. Is this a true reflection of what transpired in the Committee of the Whole? Thank you.